Welcome to the Court Reporting Academy. This will be Module 1, Section 4, Understanding the Court Process. First, we'll talk about civil and criminal matters. Criminal cases will deal with serious crimes such as murder, rapes, arson, robbery, and assault. The government brings a case against one or more defendants. The defendant in a criminal case is the person being accused of committing a crime by the government. The burden of proof in criminal cases has to be proved beyond a reasonable doubt. What does that mean exactly? Well, the burden of proof determines which party is responsible for putting forth evidence at the level of evidence they must provide in order to prevail on their claim. In most cases, the plaintiff, the party who's bringing the claim, they're the ones that have the burden of proof. This means that the burden of proof needs to be beyond a reasonable doubt. That means when evidence is presented in a criminal case, the prosecution has to prove each element of the case beyond a reasonable doubt in the minds of the jury in order to get a conviction. In a civil case, there is still a burden of proof, but it is beyond a reasonable doubt. It's held to a lower standard. The idea is that in a criminal case, we're taking away somebody's life or liberty and we're going to be putting them in jail. So they're held to the highest possible burden of proof, and it has to be proof that is beyond a reasonable doubt. There are two parts of burden of proof. One is if you're bringing a claim against somebody else, you, the person bringing the claim, has the burden to produce some evidence that the person who you're bringing a claim against either breached their duty, caused harm to you, or acted unreasonably. That's the burden of production of evidence. The second piece of burden of proof is what is the standard to be applied. In criminal cases, the defendant must be found guilty beyond a reasonable doubt, which means the evidence must be so strong that there is no reasonable doubt that the defendant committed the crime. Now we'll talk a little bit about civil cases. In a civil cases are about money, suing for money. So we have a lower burden of proof. It's called a preponderance of the evidence. And so what that really means is it more likely true than not true? Even to say 51% more likely true than not true. And that might meet the civil burden of proof. Oftentimes, when jurors are asked to sit in on a case, one that is a civil claim where a claimant has suffered damages like financial, physical injuries, emotional distress, invasion of privacy, among some other things, and they're asked, are you comfortable making decisions in this trial, knowing that the only level of proof is more likely true than not true? If the plaintiff in a civil case demonstrates that it's more likely true than not true to each element of the case, then they win, because their burden of proof is preponderance of the evidence, not beyond a reasonable doubt. The Seventh Amendment to the U.S. Constitution guarantees you the right to sue someone for loss or damages that they have caused you. That's what's called a civil lawsuit. In a civil lawsuit, the person bringing the case against another party is called the plaintiff. The party the plaintiff is suing is called the defendant. And although the U.S. Constitution gives everyone a right to have an attorney if accused of a crime, There is no such guarantee for civil cases. So, when someone chooses to bring suit against someone, they usually will need to hire a private attorney. In some cases, there are legal aid resources for people who can't afford an attorney, but they vary by each community. There are attorneys who will help someone for free by donating their time. It's called pro bono work. And you, as a plaintiff or a defendant to a lawsuit, are also allowed to represent yourself. That's called pro se. Now, we're going to dissect a case from file to trial. There's a lot of information, and sit back and enjoy this. All cases start by someone filing a complaint. You are suing somebody for whatever reason it is. And once filed, it's now a complaint. The summons is the document that is issued under the court's authority that notifies your defendant that they are being sued and that they need to take some sort of action. To begin preparing for trial or your case, both sides will or should engage in discovery. That's the formal process of exchanging information between the parties about the witnesses and the evidence that they will be presenting at trial. This is crucial because it enables the parties to know before the trial begins what evidence may be presented, so there are no surprises at trial. Discovery can be in the form of interrogatories, which are written questions that have to be answered under oath. By doing a request for the production of certain documents like books and records, accounting records, tax returns, one of the most common forms of discovery is done through depositions. That's where we're used every day, all day, participating in the discovery process. So a deposition is an out-of-court statement given under oath by any person involved in the case. It can be used at trial or in preparation for trial. It may be in the form of a written transcript, a videotape, or both. Now, by Zoom and other online meeting platforms. In most states, either of the parties may take the deposition of the other party or of any other witness, and both sides have the right to be present. Depositions play an important part of the process since they enable a party to know in advance what a witness will say at the trial. It's a fact-finding process. Depositions can also be taken to obtain the testimony of witnesses who can't appear during the trial. Say someone is much older, or they're ill, or is a doctor or an expert. In that case, that deposition testimony can be read into evidence at the trial. When a notice to appear for court is issued, it contains very critical information that is important to your job. Understanding how to read a notice, what information is contained on a notice, and where to look to find what you need to complete your end of job paperwork is important to your productivity and efficiency. There'll be a caption. The full caption of the case is included at the top of a notice of a deposition. It includes the jurisdiction in which the case has been filed, the file number, and name of plaintiff and defendant, the names and addresses of the attorneys. Then they'll have a record of what's included on the notice, along with the name of an attorney's law firm, their full street address, their telephone number, fax number, and email address. We need that stuff to complete transcripts, so it's super important when we're looking at a notice to be sure all of that information is there. It'll tell us what type of notice, the title of the document, and it should include whether it's a video conference, whether there will be a production of documents, or whether it's going to be a live appearance. The date, time, and location will be on a notice. It will be in bold letters, not always, but it helps to draw attention to the information on the notice. That's important for our schedule, to know what is scheduled for when and what time. On the next slide, you'll see an example for a case that's been filed in the Superior Court for the state of California, and it is a notice of deposition for production of documents. There are many types of proceedings that occur that are not even in a courtroom. There's hearings, depositions, EUOs, which are examinations under oath, meetings, IMEs, which are independent medical exams, and sometimes just a need to answer written questions. There's arraignments. An arraignment is the first appearance before a judge. There's review hearings. When sentencing is due on a case, we call that a review hearing. This is when the sentencing could include various consequences, such as like community service hours, a charge, a class you have to attend, or restitution you have to pay. We report all of those types of hearings. Could be a show cause hearing. That's if someone fails to appear for a review hearing. They may receive a notice of show cause in the mail. That will give you a date to appear in court, explain to the judge why you did not appear for your review hearing. There's also final pretrial status conferences. That's a conference that may be scheduled at the judge's discretion prior to the trial date. There are examinations under oath, right? These occur when an investigation is ongoing. The purpose of this procedure is for the insurance company to find out more information about their claim. When an individual signs an insurance policy, he or she agrees to participate in an examination under oath if necessary, and swears to provide honest and accurate information. An EUO can take place at any time during an insurance investigation, but a deposition only occurs if you file a lawsuit and if you need to litigate your claim. An IME, that's the medical exam, an independent medical exam. That occurs if you've been injured on the job and asked to undergo an IME. That means that a doctor chosen and paid by the insurance company examines you. Then they give the insurance company their opinion about your injury. The doctor's opinion includes the cause of your injury, your disability, your ability to work, and any future medical treatments you may require. When it comes to trials, there are a few steps before getting to the actual trial itself. There are preliminary hearings, pretrial motions. You even have the grand jury proceedings. The preliminary hearing typically takes place soon after charges are officially filed against a defendant. Preliminary hearings are before a criminal case goes to trial. The prosecutor and the defense team usually appear before a criminal court judge and make pretrial motions, arguments that certain evidence should be kept out of the trial, that certain physical evidence and testimony can be used, what legal arguments can and cannot be made. Like in a drug possession case, the defense asks the judge to keep drug paraphernalia out of the case, and the defense argues it was obtained through an illegal search of the defendant's apartment. Or a key witness, an elderly neighbor with Alzheimer's disease. is not legally competent to testify and should be excluded as a witness at trial. There are others. There's so many different aspects of before a case gets to full-blown trial. There's summary judgment. The facts of the case are not in dispute, so the court orders a judgment without a full trial. Motion to dismiss. They say the case should be dismissed because of a lack of jurisdiction, lack of evidence, or there's a settlement. And there could be other reasons. Exclusion of physical evidence. The evidence may have been obtained illegally or beyond the scope of a search warrant. Exclusion of witness testimony. There could be a conflict of interest. The witness could be unreliable, lack of competency. A motion to change venue. This may be awarded in cases, particularly those that are heavily publicized, where the jury pool may be prejudiced against the defendant, and a motion for the release of evidence. There may be evidence being held by the prosecution that is materially important to the defense. And then we have cases that go before a grand jury. A grand jury is a group of people selected to sit on a jury that decide whether to return and formally charge a person with committing a crime. That's better known as an indictment. An indictment is what formally charges a person with committing a crime, and it begins the criminal prosecution process. In the United States, a grand jury consists of 16 to 23 people. Grand juries convene for a period of 1 month up to 1 year. The grand jury proceedings are held in private. The suspected criminal is usually not present at the proceeding. The grand jury acts as an investigative body, independently of either prosecuting attorney or judge. Criminal prosecutors present the case to the grand jury. The prosecutors attempt to establish probable cause to believe that a criminal offense has been committed. They can request further evidence, witness testimony, and subpoenas of documents. The grand jury is generally free to pursue its investigations without any interference. They assess whether there is adequate bias and basis for bringing a criminal charge against a suspect. They act as sort of a buffer between the government and the people. We have non-jury trials or bench trials. If the case is set for trial, the judge is the one who will preside over the trial proceedings and decide the outcome, not a group of people or a jury. A jury trial is if a case is set for a jury trial, then the jury will decide your guilt or innocence. In each proceeding, there are certain protocols and components that are followed. Each side, plaintiff and defense, present their cases. They will each start off with opening statements. That is, a lawyer's first opportunity to address the jury in a trial. Generally, the party who bears the burden of proof, the plaintiff in a civil case or prosecution in a criminal case, begins the opening statements, followed immediately after by the defendant. The purpose of that is intended to give the jury a preview of the case. It describes the parties, outlines the nature of the issue in dispute, presents an overview of the facts and evidence so that the jury can better understand the overall case. Once both sides have had their chance to give opening statements, now the testimony begins. During each part of the examination, there will be objections. Objections are usually made by opposing counsel because of the form of the question or it has been asked and answered already, or it was leading in some form. So throughout the case, you'll be hearing some of those common objections. In a deposition setting, objections are usually only as to the form of the question, and they cannot instruct a witness not to answer it unless they get a judge on the phone to make the ruling then and there. Otherwise, the objection is placed on the record, and the ruling on that objection is reserved until the time of trial or until the judge otherwise makes a ruling. But in a court setting, objections are made, arguments on the objection are heard, and the judge will make the ruling right then and there. There are times when the judge will call counsel up to his bench. This is so that he can speak with counsel outside the presence of anyone else in the room, including the jury if they are present. And they'll discuss whatever the issue is and then place a statement on the record at that time. At times, the judge will require and request that the court reporter come up to his bench and take down that bench conference as well. Once testimony for both sides is complete, all witnesses and evidence has been presented, both counsel now have an opportunity to present closing arguments in hopes of persuading the judge or the jury to find in their favor. The case is then presented to the judge and or the jury for deliberation, and ultimately a verdict is reached. Once the verdict is announced, either side has a right to file an appeal if they're not satisfied with the outcome of the trial. Most appeals are final, though, and the Court of Appeals decision usually be the final word in the case, unless it sends the case back to the trial court for additional proceedings or the parties ask the U.S. Supreme Court to review the case. A litigant who loses in a federal court of appeals or in the highest court of a state may file a petition for a writ of certiorari. That means it's a document asking for the Supreme Court to review the case. The Supreme Court, however, does not have to grant that review. If you'll notice, we have the Supreme Court that is at the very top. We have state trial courts, we have the intermediate appellate courts, we have U.S. District Court, then the Courts of Appeal, the state Supreme Courts, and it goes to the top to the Supreme Court of the United States. There is a pattern and a process that is followed when attorneys are questioning witnesses. It starts with direct examination, then opposing counsel gets to cross-examine that witness, and it can go back and forth a few times before the process stops, and then there's no more questions allowed. It's usually direct, then cross, redirect, recross, and we have rebuttal. Direct examination is the questioning of a witness by counsel. Cross-examination is opposing counsel's turn to try and refute what that witness said on direct. Redirect allows the first questioning attorney to ask follow-up questions only on that which was brought up on cross, nothing new. Recross allows opposing counsel to refute what was asked on that follow-up testimony only. There's also what's known as voir dire examination, and it means an examination on qualifications. Voir dire in a trial with a jury is the process of jury selection during which lawyers, a judge, or both question potential jurors to determine their fitness to serve on the jury panel of a particular trial. Voir dire can also describe the preliminary questioning of witnesses, such as expert witnesses, to determine their competence to testify in a trial. And finally, voir dire can also describe any hearing that takes place during a trial and outside of the presence of the jury. So, the deposition process. As a court reporter assigned to cover a deposition, you are the most important person in the room. If you're not ready, then nobody starts. You are the one that needs to control the settings, meaning controlling the attorneys, the speakers, the colloquy back and forth, so that you can hear, so that you can understand, and that you are recording clear audio with only one person speaking at a time. The function of a court reporter in a deposition is to record everything that is said as accurately and completely as possible. That means the court reporter is always on the record once a deposition session begins. There are going to be times when one attorney will say, "Let's go off the record." If opposing counsel wants to stay on, you stay on the record. And if he says, "Well, I hired you and I'm paying for you, I get to make that decision," well, in fact, that answer is no. You don't always get to make the rules. Not in a deposition setting, anyway. Of course, in a courtroom, the judge is the ruler. And ethical rules require that the reporter not show partiality in any way. That means neither side can alone tell the reporter when to go off the record. Only if the attorneys for both sides agree to stop recording should the court reporter stop. When they're ready to go back on the record, though, there is only one attorney that needs to say, "We're back on the record for the proceedings to continue." It is also the court reporter's job to administer the oath. You'll learn more about the proper wording to use when administering oaths to children, mentally impaired individuals, and interpreters, but you are there as the uninterested party. You are not concerned with the outcome, and as a notary, you have the authority to administer oaths to witnesses. With new technology advancements, we are doing many remote assignments. There is what we call a read-on for the reporter to say out loud for all participants to hear and agree to, so that there are no issues later on. A sample of a statement a reporter might read into the record before the proceedings start might say, the attorneys participating in this proceeding acknowledge that you are not physically present in the room and that you're reporting the proceeding remotely. They further acknowledge that the witness will be sworn in remotely and that the parties and their counsel consent to that arrangement, and they waive any objections to that manner of reporting. And then you would make them state their name on the record by saying they agree. During any type of proceeding that you might be covering, attorneys may say things to you like, "Mark that question," or "certify that question." And your job is to do just that. Mark it. Make sure it is highlighted or easily found in your annotations and your notes, because that's something that eventually will go onto an index page in the front or back of a final transcript, so that anyone reading it can look on that index page and see who was questioning on what page, by whom, if there were any exhibits marked, what they were, what page they were marked on. And if an attorney says to certify the question or mark a question, it simply means that the attorney wants the court reporter to note the page and the line reference in case the attorney wants an objection ruled upon by the court at a later date. Most of these requests are put on what's called a litigation support index. That's made for the attorneys, and it's listed on that page. Instructions not to answer, marked or certified questions, requests for production of documents, so they can easily locate them. Here's an example of an index page. Notice it has the witness's name, indicates that the witness was remotely sworn, the examination by which attorney, and what page did he start on. And then you'll see an example of exhibits and what they were marked and on what page they were marked on. This is an example of a deposition support index. As you can see, there's page where they can put the page and the line number for direction not to answer, requests for production of documents, any special stipulations, or any questions that were marked. We, as a court reporter, most times are in charge of marking exhibits. Exhibits can be anything from an exemplar of a piece of equipment, a document, a picture, a sketch, an email. It can be anything that either side wants to introduce into evidence. We can either mark the exhibit with an exhibit sticker that we have in our supply bags, or an electronic exhibit stamp if you're working remotely. Exhibits are usually marked at the direction of either counsel. They will tell you what to mark it. They say they're taking the deposition of the defendant Smith in the case. There's a picture of the accident scene. Counsel could say, could you please mark this as Exhibit D1 for defendant or Smith 1? You will use the exhibit sticker or the electronic stamp and write just that on the sticker. The D1 or Smith 1, you'll write today's date, and you'll use your initials. There will be times when you arrive at a deposition or for a hearing and the witness doesn't show. That happens more often than you would think. So when it does, in certain states and in certain instances, attorneys present in the room might say to you, I would like to have a CNA, a certificate of non-appearance. It means the witness did not show up as scheduled. They did not appear at the time and place which was arranged. The certificate is normally prepared by the court reporter and then may be filed with the court or by the lawyer who arranged for the deposition. By having that certificate of non-appearance prepared, it allows the attorney to seek sanctions and fines and presents that to the court. There are other times when they don't need the CNA prepared, but they do put a statement on the record. This usually consists of a paragraph or two from the attorney who ordered the deposition and the witness to appear, and opts to just put a statement on the record, and that'll be prepared and finalized for in the event that counsel needs it at a later time. And it will usually just state the facts that the witness or even opposing counsel at times failed to appear. At the conclusion of all testimony, every witness has the right to read and sign their final transcript, or to waive that right. It's a question that you should always ask at the conclusion. Would the witness like to read and sign their transcript? If they waive their right, then the final transcript gets filed with the court. If they choose to read and sign their transcript, then they or their counsel are provided with a copy. They have 30 days to read it. They have 30 days to indicate any changes they think should be made. and then they will list them on what's called an errata sheet. That sheet will list the page number, the line number, and any changes they make. Nothing ever gets changed in the transcript. It gets listed on that errata sheet, and that errata sheet gets attached to the back of the transcript and stays with it when it's ultimately filed with the court. If the witness does not return the signed transcript along with any changes within 30 days, then the original transcript is final and will be filed with the court. Most agencies will provide the transcript along with an instruction sheet, and they send that out to counsel or the witness for signature. This is a sample of what a CNA or a certificate of non-appearance may look like. And this is an example of what an errata sheet looks like. This is the page, the line number, and any correction. And I hope you enjoyed that thorough lesson on dissection of a case from start to finish. Now for your homework assignment for this module, be sure you read in your AAERT Best Practices Guide, read over pages 1-20 through 1-33, and be sure to know the list of words and their meanings on pages 1-34 through pages 1-45.